over almost 200 articles on constitutional issues, legislative issues, how they apply to the Constitution. And everything that I do and everything that I teach is not my opinion. I teach from the words of the founders of this nation. How many of you heard the presentation that I gave last night? I don't know who's there. The book that I was reading, I need to get with Sheriff Mack, and he needs to teach me how to be a better businesswoman. I'm not a businesswoman. I'm a content person. My husband handles all that stuff. But this is the book that I was reading from last night. This is a book that I've written and I have available today. This is actually a book that I wrote to be a tool for parents to help teach their students the truth about the foundation of this nation, because they're not getting that in the government schools, and they're not getting it in the private schools either. You have to know that the same textbooks that are used to create government school curriculum are used to create private school curriculums. They're made in the same textbook factories with the same teachers and professors that were taught in the same systems. So you get the same corruption of history in your private school curriculums that you do in your public school curriculums. So here we go. Are you ready to blast off? How many of you realize that all three branches of government have failed the Constitution? Okay. Well, we won't spend a lot of time there because I gave you several examples last night. Your federal government is broken. There is no recourse left in the federal government. When was the last time you wrote your congressman and got the same letter that 250,000 other people got? If you got anything at all. I bet if Sheriff Mack writes his congressman, he never even gets a reply, because they have a blackout list. If your name is on the blackout list, you can write them 400 times and they will never reply to you. My Florida representative will not even respond to my emails. So when the federal government fails, the states are left to defend the republic. If your states refuse to defend the republic, you have to. See, it's sort of like a chain of command. Not really, because you have more authority than the state and the federal government does, but nonetheless, that's how it works. Let me ask you something really quick. Who has more power in your county? The sheriff or the President of the United States?
Sheriff.
Who has more power in your county, the sheriff or your congressman?
Sheriff.
Who has more power in your county, the sheriff or your state senator?
Sheriff.
Who has more power in your county, your sheriff or your governor?
Sheriff.
So where should you be focusing all of your attention? Yet here we are in a world, in a country where we spend billions of dollars on national elections. People, by and large, only show up to vote in national elections. And you get a very small percentage of people who actually vote in local elections. All your power is there. Let me tell you something. When I teach the history, our forefathers identified what they called a malignant and pernicious design in 1641. A malignant and pernicious design that tyrants used, that they saw over 600 years prior to their discovery of this malignant and pernicious design, that tyrants used to subvert liberty. Are you interested in knowing what the malignant and pernicious design was in 1641? Corruption of the court system, infiltration of foreign law, diminishing property rights of the people, the government inserting itself in the church, manipulation of the monetary system, and the government disarming people while the government remained unlawfully armed.
I'm sure glad we don't have those problems today.
That was the malignant and pernicious design as identified in 1641. Your local elections are your only solution. Stop being intoxicated by the federal elections. That's what they're there for. We had just inaugurated a king in January, right? And at his inauguration, we were already talking about the 2016 presidential election. Which, by the way, I'll insert my opinion for just a second. Stop looking at Marco Rubio.
Amen.
Marco Rubio is an enemy to this Constitution, and if you haven't figured that out, come talk to me later. If you want to understand the proper role of your state, the proper role of your local government, we've got to get back to some basics, some things that have not been taught for decades. How many of you have heard of the Lee Resolution? The Lee Resolution was the legislative action that gave authority for the Declaration of Independence. Unlike history portrayed in movies, they didn't just all have too much beer and fish and chips the night before, wake up, get ticked off at the king, and go sign the Declaration. This was the Lee Resolution, as written by Richard Henry Lee, was the authorization for the delegates to sign the Declaration of Independence. A 3-step process for declaring independence. Step number 1, we are 13 independent sovereign states. When did we sign the Declaration of Independence? July, right? July of 76. This is June of 76. Prior to the Declaration of Independence, the states were already independent states. Now, there's another thing that you have to understand that we're going to address here really, really quickly. That word state, to our framers, did not mean Missouri, California, Georgia, Florida. It meant Great Britain, Germany, Spain, France. It meant country. We are 13 independent sovereign countries. We are no longer bound to Great Britain. We are independent and sovereign alone. Step number 2, as 13 independent, newly formed sovereign countries, we must seek alliance with foreign nations to obtain our independence. They were 13 brand new little countries. There is no way they knew by themselves that they would be able to come up with the resources and the materials and the manpower to overthrow the most powerful government in the world. Step number 3. As 13 independent sovereign countries who have just now gone into debt with foreign nations and are inviting them to occupy our territories to help facilitate our independence, we must form a confederation. If they did not form a confederation, they would have been immediately occupied and overcome by the very foreign aid that they had received. You don't really think France was helping us because they were just good guys. They were looking to get something out of us. So the states existed prior to the Declaration of Independence. And we have then our first attempt at a constitution called the Articles of Confederation, which did not work out well for us because our framers wanted to create a very small central government. In spite of what you may have heard about the revisionists, there was not a plan to create a large centralized government by even Alexander Hamilton. Small centralized government is what they wanted, and they created one so small that it could not run. They had delegated the same powers to that federal government that we delegated to ours, but they did not give the power to levy taxes. And they did not give any power of enforcement of treaties or the power exerted by the central government that was delegated. You see, taxes are necessary. That's the bad news. You cannot run a government without taxes. Problem is corruption in taxes. When you're collecting taxes for the central government to do things they're not authorized to do, that's when you have serious problems. Not only that, if the central government is collecting taxes from the people, that's unconstitutional. The states were supposed to be collecting the taxes from the people and paying the central government because the central government, as you will see in a few minutes, is the employee of the states. Then we get the Constitution of the United States, which is why it's called the more perfect union, because it was our second attempt. George Washington was not the first president of the United States. He was the first president under the more perfect union. I want to read to you this. This is the conclusion to the Declaration of Independence, and it verifies to you what I mean about that word state. We, therefore, representatives of the United States of America, in Central Congress assembled appealing to the Supreme Judge of the world for the rectitude of our intentions, those nasty atheists, in the name and by the authority of good people of these colonies, solemnly publish and declare that these united colonies are and of a right ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and, what is this word right here? State of Great Britain is and ought to be totally dissolved, and that as free and independent states, just like Great Britain, look at this power now. This confirms to you that they were not talking about Florida, Georgia, or Missouri. They were talking about Great Britain, France, and Spain. The power to levy war, conclude peace, contract alliances, and establish commerce. And they're talking about external commerce, not internal commerce. And do all other acts and things which independent states may of right do. How many of your states understand that they have the power to levy war, conclude peace, contract foreign alliances, and establish foreign commerce? And for the support of this declaration, with firm reliance on the protection of divine providence, we mutually pledge to each other our lives, fortune, and sacred honor. Now, the liberals love international law, which, by the way, our sovereignty is the sole reason the United Nations hates us. Because the United Nations can go in and take any other country in the world, but they cannot take the United States with one fell swoop, because they know we are 50 independent sovereign countries that have come together through a confederation, much to the chagrin of Barack Obama, who calls us a consolidation. This is valid international law. This means that even the United Nations must recognize that every state in the United States is free, sovereign, and independent. Articles of Confederation, our first attempt. Article 2 was the precursor to the 10th Amendment. Each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right. What were those powers, jurisdictions, and right? Levy war, conclude peace, contract alliances, establish foreign commerce. Not by this confederation, not consolidation, expressly delegated. Now that word delegated is very important. We'll catch that in a second. What is the nature of our republic? The states are united in a compact or a contract. The crazy thing is, every single lawyer, now you guys know that lawyers are nothing more than law students who have passed the bar, right? And judges are nothing more than lawyers who've gotten a promotion. So the sum and total of what your judge knows is based on what his practice of law is and what he learned in law school, and they don't teach the Constitution in law school. They teach constitutional law, which is worse than teaching nothing at all, because constitutional law classes teach that the Constitution, that men and women in black robes know more about the Constitution than the men who wrote it. Which is why you get this living, breathing document lie, which tells you that these men and women in black robes can tell you what the Constitution means regardless of what the founders meant, and it is based on what they believe in that day and that time. But the Constitution is a compact or a contract. Now, a compact is the same thing as a contract, except a compact is a contract between governments, and a contract is a contract between people. So I use those words interchangeably because I'm speaking to laymen. So when I say contract, you have to understand it means compact because the states are governments, little countries, united together. The interesting thing about this, how many of you have heard that the Constitution is a contract between the people and the federal government? Yeah? This is interaction, so we're going to keep talking about this. I'm going to need your feedback. That is a popular misconception. It cannot be a contract between the people and the central government because the central government did not exist until the Constitution was ratified. becoming a party to the Constitution, that is a temporal impossibility. The Constitution is a contract between the states. The Constitution is a contract. The states are a party to that contract, which is important because as we run through the framers' perspective in this, they are going to several times refer to the Constitution as a compact, or they'll refer to the states as the parties to that compact. The states created the central government. Is that a stretch?
Do we get that at all?
I don't know. Do you get it?
Well, that's why we had you here, so I was hoping you could make people get it.
I'm trying. Okay, look. Which existed first? The central government or the states?
States.
The states existed in June of '76, right? Prior to the Declaration of Independence. The states then got together and created the Constitution in 1787, ratified the Constitution. The Constitution created the federal government, right?
Right.
So the central government is a product of the Constitution. The states are the parties to the Constitution. Since the states created the Constitution created the central government, the states created the central government. Do you see that? Yes.
Let me ask you that real quickly. So then the states created the central government and surrendered everything over to the big federal.
We're getting there. We're getting there.
Right.
We're getting there. We're going to do this in small pieces. Yes.
What about the question where, wasn't it referred to the people though, directly to the people, for the people to ratify by their representatives, so that it was a contract between the people? That's what I've always thought.
Well, you have to understand, I'm not going to do this in 45 minutes. So listen. The 9th and 10th Amendments help explain that, okay? The 9th and 10th Amendments are not like 1 through 8. 1 through 8 are the Declaration of Rights. The 9th and 10th Amendments are provisions in contracts called, oh, and the word's just going to come right out of my mouth. Oh my goodness, how did this happen? Rules of construction. The 9th and 10th Amendments are called rules of construction. In a contract, a rule of construction tells the reader of the contract how to apply every provision within the contract. The 9th Amendment declares all the rights belong to the people. Okay? Power emanates from rights. Power doesn't exist by itself. It must come from rights. All the rights belong to the people. All the power belongs to the people. But when we enter into governments, we delegate certain powers to certain levels of government to achieve a purpose for us. Several times they say we surrender provisions of liberty in order to maintain government. Why do we do that? The Constitution was created to secure the blessings of liberty. The Constitution was not created to create a central government. It was created to secure the blessings of liberty. The mechanism we chose to secure the blessings of liberty was a central government from the international perspective. Now, the people are the ultimate parties to the contract, but they delegated the contracting authority to the states. So we are never separated from our states. Can a state exist without its people? It does not have a life on its own. So that's why the 9th and 10th Amendments are there, is to keep us linked in understanding the source of the power and the fact that all the rights belong to us. The states are the creator of the central government. They created a limited government with enumerated specific powers, reserving all other powers to themselves. The 10th Amendment. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. Okay? What's that fourth word in that sentence? Delegated. Does that mean relinquished? Does that mean surrendered? If I am the manager of Chick-fil-A and I delegate the authority to one of my employees to make the fries, and that employee shows up one day and says, "Sorry, boss, I ain't making no fries." Am I relieved of my responsibility as the manager to make sure that that store makes fries? No. It is still my responsibility, is it not? I better find somebody to make some fries quick, fast, and in a hurry. So, is it illegal for me to find someone else to make the fries? So if the states possess, at the Lee Resolution, the power to declare war, conclude peace, contract alliances, and engage in foreign commerce, and the central government refuses to protect our borders, are the states relinquished from that responsibility? No. Is it illegal for them to find someone to protect their borders for them? No. See how easy this is? Notice that the powers were delegated. This implies a source. The rights belong to the people through the 9th Amendment. All the powers emanate from rights. We have delegated certain powers to the states because as people, Sam Adams said, the natural rights of the colonists are these: first life, second liberty, third property, together with the right to support and defend them. We possess the right to protect our own borders as people, simply because we breathe. We have delegated certain authorities to the states. The states then delegate certain power to the central government to do a job for them. When the power comes from the people, that is a republic. But when the power comes from the government, it's a kingdom. That's important to understand, because there is a fine line that must be maintained by the people to prevent a republic from turning into a kingdom. Madison wrote in Federalist Papers 45, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which remain in the state governments are numerous and indefinite. The former, meaning the power delegated to the federal government, will be exercised principally on external objects: war, peace, negotiation, and foreign commerce." Does that ring a bell? Isn't that what the states possessed at the Declaration of Independence? Well, we have delegated those: war, peace, negotiation, and foreign commerce. External objects. Your federal government was designed to be an agent of the states as a foreign ambassador to foreign nations. It's why we have one president instead of a tribunal or a committee, because that was a discussion. They reasoned, among other reasons, that they needed to have one man because they were working in a world of czars, kings, emperors, and we needed a foreign diplomat to represent the states. Now, this is actually reinforced by the proper understanding of the General Welfare Clause, and I note proper understanding of the General Welfare Clause. The General Welfare Clause was never designed to tell the federal government they could do generally whatever they wanted. The General Welfare Clause was incorporated because during the Articles of Confederation, the president was creating treaties that would benefit one state and detriment the other. So these treaties, these foreign commerce contracts, would make New York have a boon and bankrupt North Carolina. So North Carolina is refusing to honor, and this is just a general example, not a specific example, but in my example, North Carolina is refusing to honor these treaties because they're losing their shirt, and New York is getting all of the benefit from this. So each other because North Carolina is not honoring the contract that's going to get New York their money. And then the foreign nations that we've contracted with are ready to wage war on us for breaking our contractual agreements. So we incorporated the general welfare clause to show that not the purpose of the government was to do generally whatever they want, but the purpose of the power that was delegated to them was for the general welfare of all the states. You see, we delegated to them war, peace, negotiation, and foreign commerce. And the general welfare clause says, when you engage in war, when you engage in peace, when you engage in negotiations and foreign commerce, you cannot benefit one state over the other. You must engage in war, peace, negotiation, and foreign commerce with the general welfare of the entire Union in mind. The powers reserved to the several states will extend to all objects which in the ordinary course of affairs concern the lives, liberties, properties of the people, and the internal order, improvement, and prosperity of the state. If the federal government was delegated war, peace, negotiation, and foreign commerce, and everything else belongs to the states, are there any powers just floating around in the ether somewhere? Do you see, can you name for me something that is not war, peace, negotiation, and foreign commerce, or everything else? Everything's taken care of here, right? So, what that tells you is, if the federal government is doing something besides war, peace, negotiation, and foreign commerce, those external objects, don't they have to steal that power from the states?
So they have to pay us and we give it to them.
Yeah. Federal powers are few and enumerated. The states' powers are numerous and reserved. There are no gaps. If the federal government uses a power outside of the delegation in the Constitution, it must steal that power from the states. This is essential to understand when you read what the framers said. Remember, the purpose of the Constitution is to preserve liberty, to create a union of states, a confederation, not a consolidation, and create and define a limited federal government. So, if the federal government is not defined by the Constitution, what defines the federal government? Well, the states did in the Constitution. If the federal government is not limited in its power by the Constitution, what is the limit of the federal government's power? Jefferson said, they will view this as a seizing of the rights of the states and consolidating them in the hands of the general government with a power to assume and to bind the states, not merely in cases made federal. What are those cases made federal? War, peace, negotiation, and foreign commerce. He says, if you allow the Constitution to not be the limitation of the federal government, then they will not only bind you in war, peace, negotiation, and foreign commerce, but in all cases whatsoever. That's what Obamacare does, by the way. Binds you in all cases whatsoever. If the standard for the government intruding on your liberty, per the Supreme Court, is they must establish a significant governmental interest. And once they establish a significant governmental interest, the Supreme Court will give them the power to do just about anything. Obamacare establishes a significant governmental interest in your health care, right? Which means it establishes a significant governmental interest in your health, right? Which means it establishes a significant governmental interest in your healthy living. See how lawyers work? Which means they have a significant governmental interest in your healthy living. They have a significant governmental interest in where you live. Maybe you live in a rural area and the government determines it takes too long to get an ambulance to your house. They can determine that people can only live within a certain radius of any given hospital, and you can no longer live outside that radius. They have a significant governmental interest in what you'll eat. Thank you to the Food Safety Modernization Act, they have given themselves the authority to eliminate your gardens. And they'll do this because they now have significant governmental interest in what you eat, and they'll tell you, we have to ensure that you're living healthy. And that means you can only eat food that has been approved and regulated by the FDA. So you can't have your own chickens, you can't have your own garden unless you allow the FDA to come in and inspect your home. He says that would be to surrender the form of government we have chosen and live under one deriving its powers from its own will and not from our authority. A federal government not limited and defined by the people, a federal government whose only limitation is its own will, is a kingdom. For the federal government to enlarge its powers by forced construction of the constitutional charter, which defines them. What is that enlargement through forced construction? The way they apply the General Welfare Clause and the Commerce Clause. By saying the General Welfare Clause means we have the power to do anything we want to do, instead of saying that's the purpose for the power that we've given. He says to do this is to destroy the meaning and effect of that particular enumeration. What? Please answer me this. Why in heaven's name did our framers go through the problems and the debates and the challenges to create specific enumerations for the general government in the Constitution if they weren't supposed to stick to it? What is the purpose of even having enumerations? Why didn't we just establish a kingdom and say, do whatever you're going to do, and we'll stop you when we want to stop you. We'll come and chop off your head when you've taken too much, because that's how kingdoms work. Your only recourse for a kingdom out of control is to chop the king's head off. See, they didn't want that. They wanted to give us something greater, a government of the people, by the people, and for the people. So Madison is saying, if you enlarge, you allow the government to say the General Welfare Clause means we can do generally whatever we want. You're transforming our present Republican system into an absolute, or at best, a mixed monarchy. So what do? We must seek our answers from the creators of the Constitution. Now you will get a great deal of kickback on this. That's what I brought to my Senate President, Don Gates. He looked at me and said, "Oh, really? Have you spoken to Madison lately?" I said, "Well, actually, Mr. Gates, I have. It's called the Federalist Papers. You ought to read them every now and again." And then he scoffed and walked away, mocking the framers of this nation and my idea that they had something to say. I said, "I thought you claimed to be a constitutional conservative, Mr. Gates." At which time he turned on his heels, because he's turned his back on me and is walking away. Turns on his heels and looks at me and realizes, because we were just come out of a Senate session, that there are a large crowd of people behind me, several of them being members of the press. He says, "I took an oath to support and defend the Constitution." I said, "Well, maybe you ought to learn something more about that document then." He says, "Well, Miss Hall, I'd be happy to read anything you have to send to me." I sent him this lesson. He sent me an email telling me I needed to be shot or hanged for believing what I'm teaching you today. Why do we have to seek our answers from the Creator? Because the Constitution is a contract. And every attorney learns in Contract Law 101, in their first semester of law school, that whenever there is a problem with the application of the contract, whenever there is a provision that seems vague, whenever there's an application that you're not quite sure how it fits in the original contract, Contract Law 101 tells the judges and the courts that they must return to a legal point in time the meeting of the minds. This meeting of the minds is where the drafters of the contract sat down and discussed all the provisions within that contract. Why are we creating this contract? What is the purpose of this contract? What will this contract do? If we're creating a business, what will be the responsibilities of the entity within that business? And that is when the court then applies those provisions. The ironic thing here is this. The Constitution is the only contract in the United States in which judges and lawyers refuse to follow contract law. Because they tell you the meaning of the minds is not important. What's important is what you want it to mean now. Jefferson says, whenever the general government assumes an undelegated power, its acts are unauthoritative, void, and of no force. So let's look at this. If the general government assumes an undelegated power, where does that power have to come from? From the states, right? Because it's either war, peace, negotiation, and foreign commerce, or it's everything else. So what Jefferson is telling you, that whenever the general government steals power from the states, it's void. It has no authority. If I steal your car, do I have the legal authority to sell it? Do I?
No.
If the federal government is stealing power from the states, Jefferson is saying that power is no authority. Let me ask you this. If you steal my car from me, and I show that I have the title deed and I'm the proper owner, that car has to be given back to me, doesn't it? Even if it's been sold. The buyer of the car loses out. It has to come to me. You have a title deed to your power, states. It's called the Constitution. You don't have to sue to get that power back. You simply need to step up and assert your title deed.
Don't change that yet. I just want to reinforce one point here. Especially for you sheriffs, county officials, county commissioners. I'm really fed up to hear with the comment from local officials that say, the only way we stop this is go to court.
Well, Madison is gonna reassert this point.
I'm sick of that, okay? That's stupid and wrong. It's stupid. Anybody says that is a fool or a liar. We swore.
And illiterate.
We swore, well, yeah. Fool. So, we swore the oath to uphold and defend the Constitution. We're gonna say, well, citizen, if you have the money to go sue and stop this, then you can get it back. And yet we're sworn guards of the Constitution, and we're going to allow the federal government or state government this kind of stealing authority, steal this, and we'll tell our citizens, can't do anything about it, then you go to court. That'll cost you $250,000 in the next 5 years of your life. You have to. So that's the only way you get justice in America then. So everybody that destroys the Constitution and goes against it gets to keep doing it until we go to court.
What was the first provision of the Malignant and Pernicious Design? Corruption of the court system.
Yeah.
Okay. James Madison, in the case of deliberate, palpable, and dangerous exercise of other powers not granted, the states have the right are in duty bound to interpose. Why are they duty bound to interpose? Because the power belongs to them. They simply delegated to it. They've created the federal government. It is the duty of the states to maintain the creation within its created limits. Otherwise, the creator then becomes superior, or the creation becomes superior to the creator. Interposition, Jefferson called it nullification of the unauthorized acts of federal government. Notice he didn't say the lawsuit. Nullification. What is nullification? That is the states and the people proclaiming, the federal government is not our master. The states and the people are the masters of the Constitution. We do not have to, and we will not comply. It does not require a lawsuit. It simply requires a declaration that the car belongs to us, we have the title deed, you have no authority to steal this car from us and sell it, and we will not allow you to do that. Jefferson says it's the rightful remedy that the several states who formed the Constitution, being sovereign and independent, like France, Spain, and Italy, have the unquestionable right to judge of its infractions, and that a nullification by those sovereignties, who are the sovereignties? Of all unauthorized acts done under the color of that instrument is the rightful remedy. Some will say no to nullification. Why? They'll tell you it's not in the Constitution. They'll tell you the Supreme Court says nullification is not lawful. They'll tell you the Supremacy Clause prohibits it. But those who lived it said to disallow nullification would be an unconstitutional act of tyranny. The doctrine which denies to the states the right of protecting their reserved powers, right? Isn't that what the 10th Amendment says? Which would vest in the general government. Now this parenthetical is very, very important. He says it matters not through which department. How many branches of government do we have? Legislative, executive, and judicial, right? So you're telling me the judicial branch is part of the federal government, right? Okay, hang on to that. That's important. Because Calhoun is saying it doesn't matter whether it's the legislative, the executive, or the judicial that's going to assume this power. He says that is incompatible with the sovereignty of the states and the Constitution itself. How can a state remain sovereign as the 10th Amendment declares, as the Declaration of Independence declares, as the Constitution declares, as the Lee Resolution declares? How can it retain sovereign if it does not retain its power? If the general government has whatever power it wants over the states. And if the general government has whatever power it wants to take, what is the purpose of the Constitution? See, to allow this transgression is completely contrary to the Constitution, which means you have eliminated the basis for our federal union. So it's not in the Constitution. Well, yes, it is. It's called the 9th Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. What you have to understand in interpreting this, what our framers wanted us to know, expected us to know, was there was a great debate over the incorporation of the Bill of Rights. There was a huge argument over this. We did not have a Bill of Rights when we ratified the Constitution. It was something that they debated over incorporating. Richard Henry Lee and James Madison leading the way for the incorporation of the Bill of Rights, among other things, other people within specific provisions, said we must have a Bill of Rights, Richard Henry Lee said, to be a sentinel for the people in those unavoidable periods of inattentiveness. They knew through history that people would become pacified in prosperity. They would become lazy in luxury. And Richard Henry Lee is saying we must have this Bill of Rights to be a sentinel. What is a sentinel? A guardian and a watchman. Does the sentinel have the power to defeat an army at the door? It does not have the power. Sentinel's only usually one or two guys, right? The sentinel is the alarm to awake the army, right? You see, the Bill of Rights is not there to protect your rights. The Bill of Rights cannot protect your rights. Can the Bill of Rights pick up a pen and write your congressman? No. Can the Bill of Rights go sit in your congressman's office and demand that every law passed is compliant with the Constitution? Can the Bill of Rights pick up a sword? The Bill of Rights is not a protector of your rights. The Bill of Rights was incorporated to be a sentinel, to be an alarm. Problem is, if you don't know what your rights are, it's a silent alarm. Quick pop quiz. You ready? Don't answer this question out loud, because you must have a personal assessment of the answer to this question. Close your pocket constitutions. No cheating. No mumbling, no whispering, no mouthing the answer, because your neighbor must have an honest assessment. There are 5 individual protections in the First Amendment alone. Name all 5. Not out loud. I know you can. Some of you will have to admit you can only name 4. Some will have to admit they could only name 3. In a crowd this size, it's possible we can only name 2 or 1, some of you. My question is then, if you do not know what your rights are, how do you know they're not already gone? It's an alarm that becomes a silent alarm when you don't even know what your rights are. Hamilton said, if we incorporate these Bill of Rights, it's unnecessary and it will be dangerous. He said, why do we have to tell the government to not touch something that we've never delegated a power for them to touch? We've only delegated war, peace, negotiation, and foreign commerce. Why do we have to tell them, he says, for example, why should we tell them not to infringe on our freedom of press when we've given them no authority to touch our press? He says if we do this, one of 2 things will happen, if not both. 1, the federal government will say, you've made us a list. It's a great list. We don't want to touch anything on that list because you've gone to such great lengths to make sure that there was a list that we wouldn't touch. However, this press thing, it's a little vague. And since it's so important, it's on the list. We have to know what press is. And Madison said, what you will do by telling them that they can't touch the press is give them the authority to regulate it through the definition of that word. He said it is impossible to define press and eliminate its destruction. By defining it, what you do is the government says, well, this is press, we won't touch it, but this is not press, so we have the right to regulate it. Did you hear Dick Durbin say just the other day? Well, you know, we know what press, we know what a journalist is. We know that Fox and AP, they're journalists. But is a blogger a journalist? Is a tweeter a journalist? He says we need to ask 21st century questions about a provision that was placed in the Constitution over 200 years ago. You know what? I'm sorry, Dick. It's the First Amendment, and I don't need to be a government-approved journalist to get protection. But the very thing that Hamilton was warning me about is coming before us. The other thing that will happen is this. The government will say it's on the list. You've made this list. It's a great list. We won't touch anything on that list. However, that one's not on the list. Nullification isn't in the Constitution, so it must not be a protected right. You see, Madison's solution to this great debate was the 9th Amendment. He says, I can solve this problem in the ratification debates. He says, I can solve this problem that Hamilton has with the Bill of Rights. We can put this in there. What does it mean? The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. They all belong to us, whether they're on the list or not. That's what the 9th Amendment says. Not only that, if it's on the list, you can't do anything to it. You can't define it away, you can't regulate it away. Sam Adams says, among the natural rights of the colonists are these. First, a right to life. Secondly, to liberty. Thirdly, to property. Together with the right to support and defend them. Nullification is a natural right. nullification is your right to support and defend life, liberty, and property. And it's right there in the 9th Amendment. Say that, leave it? Right now?
Well,
When we get back?
as soon as I get up, I want to let you.
Okay, all right. Some will tell you the Supreme Court has the final say. But Jefferson and Madison disagree. Jefferson says, the idea that the general government is the exclusive judge of the extent of the powers delegated to it stop nothing short of despotism. If the Constitution is not the limitation of the powers of the general government, that's despotism. Why? Because he says the discretion of those who administer the government and not the Constitution will be the measure of their powers. The Constitution will no longer be the limiting document that it was meant to be. It will only be left to the will of the sovereign. Now, I love this from Madison because Madison gets right to the point here. And this, Sheriff, you're going to love this one. Okay? Love this one. If the decision of the judiciary be raised above the authority of the sovereign parties to the Constitution. Who are the sovereign parties to the Constitution? If the judiciary be raised above the states, dangerous powers not delegated may not only be usurped and executed by other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. Do you know that Justice Scalia just this last week issued an opinion that says your regulatory agencies have the ultimate power to decide their own jurisdiction? That the courts have no say in that at all? He checked themselves out, which means now the EPA has unlimited authority to get in your house because they now have the unlimited authority to determine their own jurisdiction. That is a sanction of dangerous powers. But he says this: the ultimate right of the parties to the Constitution. Who are the parties to the Constitution? To judge whether the compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive or legislative. Is there any question that the Supreme Court is the ultimate arbiter of the Constitution? Who is the ultimate arbiter of the Constitution? The states. The Supremacy Clause prohibits it. Now, this is my favorite argument because it's the easiest to knock down. The other ones are really easy, but this is just a matter of literacy. Hamilton says in Federalist Paper 78, no legislative act, therefore, contrary to the Constitution, can be valid. I know we like to redefine the meaning of the word is, but you can't get much simpler than no legislative act, contrary to the Constitution, can be valid. He says to deny this would affirm that the deputy is greater than his principal, that the servant is above his master, and the representatives of the people are superior to the people themselves. Don't they believe that? Who created the Constitution? Who created the Constitution? The states did. Who created the general government? So if the states are made inferior to the general government, isn't that the creation becoming superior to the creator? Don't we have a classification for that? It's Frankenstein, right? I'm getting the time signal. Here we go. Ready? The Supremacy Clause. The Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. No legislative act contrary to the Constitution can be valid because the Supremacy Clause says in and of itself, the only way it is the supreme law of the land is that if it is made in pursuance of the Constitution. You have to be illiterate not to understand that. That's why Hamilton said no legislative act, therefore, contrary to the Constitution, can be valid. Is that the one you wanted?
No, the 9th Amendment. Yeah, right there.
All right. Do you understand now who created this Constitution? You understand they created a limited and defined general government. Who is the creator of the Constitution? Who is the ultimate authority for the power? The people have all the power. We delegated to the states. The states delegated power to the federal government to be an agent for them. The federal government is an employee of the states. And when your states refuse to make their employees do their job, you now have that authority.
How can we get the president to quit making so many executive orders?
How do we get the president to quit making so many executive orders? You get your states to refuse to enforce them. He can make executive orders like Pez candy all he wants. They have no authority. He's stealing your car. He's got no authority to sell it. You just simply have to say, we own the title deed and it's not valid here. Simply not valid. War, peace, negotiation, foreign commerce. That's all your federal government's supposed to be doing. Is healthcare in that? Is the environment in that? Is education in that? Is the Department of Transportation in that? Energy. Forest services. Is the federal government authorized to do any of those things? Let me ask you something. When you take money from the federal government to do those things, you are relinquishing your authority. Does the federal government have any right to be in your sheriff's department? No. Don't take their federal money. You are becoming addicted to the morphine. Of all the Bill of Rights, is there one that's more important? Yes. The 9th Amendment is your most important amendment in the Bill of Rights. Because it is your title deed to absolutely everything. It gives you that ultimate authority. And not only that, it describes how the entire Constitution is to be interpreted. Second, then, would be the 10th Amendment.
Ultimate, yeah, now.
One quick one. What does the 17th Amendment do to this contract?
The 17th Amendment. How many of you know what the 17th Amendment is?
Popular ratification of senators.
All right. Prior to the 17th Amendment, our senators were hired by the states. To represent the states. Your senators represent the states, which is why there are 2 senators for every state. How many of your senators realize their primary job description is defense of the 10th Amendment? What we did, the progressives of 1912. Do you know who the leader of the progressive in 1912 was? Teddy Roosevelt. The loved Republican President Teddy Roosevelt was the leader of the progressives of 1912, in which they perpetrated a lie on the people that the 17th Amendment needed to happen. Why? You see, prior to the 17th Amendment, the senators were hired, appointed by the state legislators. There was no general election, which meant if the senators did not do their job, they were fired on the spot. There was no recall election, there was no nothing. They were at-will employees. Our framers called this the power of automatic recall. When we ratified the 17th Amendment, we changed over to a popular election cycle, which gave them guaranteed tenure for at least 6 years. Our framers gave us automatic recall for a specific purpose. Richard Henry Lee tells us that purpose. The purpose was to keep special interest groups and lobbyists out of the federal government. When we moved to a direct election of our senators, meaning the people only had power to influence their senators once every 6 years, instead of every single day their job being on the line. When we checked out, the special interest groups and lobbyists checked in. And that's why we're now controlled by special interest groups and lobbyists, because we believed a lie and exchanged our power for sleep.
Real quick. We're trying to move over to Charles Steve, and we want to really hear from them, and we're going to try to save some questions for all of us at the last 15 minutes. I'm gonna go about 10 now, and I'm gonna give 10 to Charles and 10 to, we're gonna just do body of questions. But what I handed you is a copy of the Supreme Court decision where 7 sheriffs won against the federal government. The 2 that ended up at the federal government, it was about, what do you do to me?
I just took it down. I was trying to hurry up. I got a little bit
I swear, she's like having another wife around. Yeah.
You're a Mormon?
Yeah.
Mac, for instance, when Scalia talks about jewels, spheres, sovereignty, one sphere is really the 4 enumerated you talked about, war, peace.
But it's also a very small sphere.
Correct. And
That's,
so I always
that's
thought
the
of
point he never
people,
made.
but they're not. One is the universe because it's
Correct.
everything not in the smaller sphere.
I even say that in my presentation. The 2 spheres that Scalia addressed in here, he just didn't reinforce the size that they're supposed to be.
Yeah, they're not even.
Right, Mike? Yeah. So what Kris just said, I mean, there's only these enumerated powers in Article 1, Section 8. And every sheriff needs to be familiar with that because you have to defend your jurisdiction against anything outside Article 1, Section 8. So the federal government goes out those 17 assignments that dealt with war, and say it again?
War, peace, negotiation, and foreign conflict.
That's all they get, and there's 17 things that are listed in Article 1, Section 8 that allow for those 4 things to happen. Anything outside that, you as a sheriff and sworn constitutional guard have to stop it. And so that's what state sovereignty is. That's the only way. What did I show yesterday? The 2 words. What were the 2 words I showed and told you not to forget? That all of this is rendered express. Okay? Now, that rendered express is in this little book you have. This is a highlighted version of the Supreme Court case. Okay, good. Now, 9th Amendment. Scalia wrote this decision, and I've always loved him for what he did in this, but he's wrong so much it's not even funny. And he was wrong a couple of times in this decision, because he said the states surrendered powers to the federal government. What does the 10th Amendment say the states did? Delegated, which means, like Kris just pointed out, that we're the boss. If I get to delegate to you, I'm your boss. You blew it, so I delegated to we. Over here. That's his name, not the product that he has. So, that makes me the boss. So I delegated to the federal government some assignments. They screw it up. What do? I can take it back and protect my own headquarters.
Right.
And yet, no, we go ask permission from their courts and say, oh, gee, I wonder why we lost that one. You know? No, stop going to court and start doing. And just start erecting the barriers. Now, what I gave you this for is so that there's a lot of these mainstream sheriffs still, and some of the mainstream legislators still, that want to think that the Supreme Court has ultimate authority, and that it has to go to court. It already has. You don't have to go to court again. A couple of dumb sheriffs, one from Montana, these naive little sheriffs, one from Arizona, one from Montana, Prince, went all the way to the Supreme Court on this issue that they can't tell me what to do because, as she just pointed out,